Thank you for joining us for this important interview as we discuss very important updates that happen in the Attorney General's chambers and in relation to the legal affairs of Guyana. I have with me the Attorney General and Minister of Legal Affairs, the Honorable Mohabir Anil Nandlall, to discuss the Caribbean Financial Action Task Force, their assessment that was concluded just a few days ago. Minister Nandlall, thank you so much for joining me.
It's a pleasure to be here, and good evening or good morning to your viewers.
So, walk us through the importance of this assessment. What does this mean for Guyana, and what was the rationale behind even having this assessment conducted?
Well, your viewers would know, as an educated public, that Guyana is part of the global framework, and part of that global framework requires a protective mechanism, statutorily and administratively, to combat certain identified global offenses. Those offenses include financing, financing terrorism activities, terrorism itself, money laundering, organized crime, and the proceeds of crime. Globally, there is an international organization called the Financial Action Task Force that is responsible for managing countries to ensure that their legislative and administrative national framework comply with the acceptable international standards. It is recognized that these offenses permeate the globe, and therefore to effectively combat them, every corner of the earth must be strengthened and must have a common framework to battle these perils of society. The Financial Action Task Force has established satellite monitoring organizations across the world. In this part of the hemisphere, the Financial Action Task Force is that monitoring unit. Guyana falls under the jurisdictional purview of the Caribbean Financial Action Task Force. So the way the thing works is that the Financial Action Task Force disseminates the prescriptions, the recommendations, the guidelines, the imperatives, and the directives that have to be implemented. The Caribbean Financial Action Task Force now is tasked with the responsibility of ensuring countries falling within the umbrella jurisdiction of the Caribbean Financial Action Task Force actually implements and effectively discharge those protocols and directives. At periodic intervals, examinations and assessments are done to ensure compliance. These examinations are done by peer review, meaning that member states review each other, and it is done on a mutual evaluation basis. What that means is that both the examining countries and their representatives and the examined country or the subject of the examination coordinate together, and that's where the mutuality comes in, to conduct this review. Once the review is done, it's done in two forms. From a distance, where you review the protocols in the jurisdiction, you look at the laws, you look at the administrative framework, and then you come to the jurisdiction and you do an on-site examination, where after you would have looked at all the documentations, all the risk assessments that were done, all the reviews that were done on paper, you come now armed with that information and you carry out now an on-site review to ensure that practically and pragmatically and effectively what is in paper exists also in reality.
Yeah.
So there is an engagement, or there are engagements with the various sectors that form part of Guyana's AML-CFT structure. More likely than not, they include the financial sector, the law enforcement sector, the extractive mining sector, the legal sector, of course, and they also review important adjunct or stakeholder organizations, so identified sectors of the private sector, the professional bodies like lawyers and accountants who play an important part in the whole structure, the real estate industry, for example. They randomly invite them and interrogate them, for want of a better word, to get, I suppose, a working and actual understanding of how the system operates in real time and practically. So that on-site visit was concluded Friday. It commenced 2 weeks prior, and it brought together the assessors, of course, assessors who came from the Cayman Islands, I believe Grenada, Trinidad and Tobago, and I believe St. Lucia. They are all part of the CFATF appointed assessors, and they did their on-site examination. Now, before they could have reached that stage, of course, as I said, it's a several-pronged process. So it would have begun nearly 2 years ago, the initial stages that would have required Guyana to prepare a whole set of documentations and satisfy a whole set of requirements. And then the on-site would have commenced. So, for example, legislatively, we were required to pass a number of laws, and we passed them. The National Compliance Commission Bill, the Anti-Money Laundering, Countering the Financing of Terrorism Amendment Bill, the Real Estate Bill, and over the past 2 years, a whole host of other pieces of legislation to satisfy the legislative requirements. Then we would have had to execute a number of other important decisions establishing administrative administrative machinery that would have implemented the recommendations that would have been promulgated to Guyana. All of that were done, and then the on-site came.
So, after this entire process, recognizing that it's concluded now Friday last, what were some of the findings? And particularly, was Guyana lauded in any way for any of these things that have already been done?
So, it's not yet completed.
Okay.
It's an ongoing process. What was completed was the on-site component of the process. Upon the conclusion of that, the team conducting the exercise is required to issue what is called a report, for want of a better. I can't remember the technical terminology. But a report is required to be issued upon the conclusion of that on-site visit. That report is highly preliminary, as the first thing. And you are not required to ask questions about the report. That report. That report will then form the basis of a draft mutual evaluation report. That draft mutual evaluation report will be sent to Guyana. And we will be required to read it and to query, if we wish to query, issues raised in the report. We are required to clarify. We are required to submit additional information if we feel that a particular issue was not properly addressed or it was not wholesomely addressed, or we feel that the assessors did not have the full benefit of the available data or the available legislation, or worse yet, there is a misunderstanding or a misinterpreting of our laws, or there is a fallacious understanding of any aspect of our administrative structure, we are offered an opportunity to proffer our view and request a rectification. And that's a mutuality of the process. When our input would have been received, then the draft mutual evaluation report is prepared and will be presented at a plenary session of the Financial Action Task Force. That is expected to take place early next year, I believe in Aruba, I'm not sure.
Were there any shortcomings that were identified in the preliminary findings?
So, this is a comprehensive exercise. The review conducted related to a wide number of areas of financial and economic activities, of the functioning of multiple agencies, both on the government, on the state, and in the private sector. I say that so that your viewers appreciate the magnitude of the exercise. In no exercise of such magnitude will you ever have 100% pass, for want of a better word. In such a comprehensive analysis, you're going to have multiple pluses and minuses as well. One would hope that you would have far more pluses, far more plaudits than criticism. In this regard, we got far more positives than negatives. So the Ministry of Legal Affairs issued a public statement. And in that statement, we disseminated what essentially was a verbatim copy of the report which we received from the CFATF assessment team. And perhaps I should read directly from the report so that your viewers can accurately interpret for themselves what the report found. In the main, the initial high-level findings found that Guyana has good coordination for the identification and mitigation of money laundering and terrorist financing risks through the National Coordination Committee. That's a local committee which we established. It also acknowledged the risk assessments Guyana has concluded, including the 2021 National Risk Assessment and its wide dissemination among stakeholders. Risk assessment is to look at your jurisdiction in accordance with the requirements and identify where the risks are from a money laundering perspective. The support of these actions through the national policy and strategy were also examined and found to be acceptable due to the completion of a number of policy items, such as amendments to key AML-CFT related legislation, the legislative creation of the Guyana Compliance Commission, and the Real Estate Agents Authority, that's in the Real Estate Agents Bill, and the codification of the Special Branch Anti-Terrorism Task Force. That's what we established in the new sets of amendments.
Right.
With regard to supervisory authorities, the initial findings found that most of these authorities demonstrated a risk-based approach, that is the recommended approach, as well as the use of preventative measures. The team also noted the support that the Financial Intelligence Unit plays in providing guidance for supervisory authorities.
So that's what it really says.
And that's then it goes on to then identify a few shortcomings. For example, one of the shortcomings identified is that the treaty office within the Ministry of Home Affairs must be resourced more adequately. Now, that's a fair assessment. Now that we know that, obviously we will work to correct that deficiency. And there are some other minor criticisms made. For example, they say that the legal profession and the accounting profession were not properly regulated. Now that is true, because we did not have a law to regulate them. We did not have a law to regulate them because the Jamaica Bar Association sued the Jamaica Attorney General when they attempted to pass a law that would bring the legal profession and the accounting profession by extension under the AML-CFT regulation. It was decided, and that's the identical issue facing Guyana and many other countries in the Caribbean. It was agreed that we will await the outcome of that litigation. Rather than start litigation in Guyana and start litigation in another country, the identical issues are captured in this case that was filed in Jamaica. The case went to the Jamaican Court of Appeal and then traveled all the way to the Privy Council in England, which is Jamaica's final Court of Appeal. And the Privy Council ruled that the contentions that the lawyers were advancing were without merit and could not have been and cannot be the basis for their exclusion from the AML-CFT network and framework. The lawyers essentially were arguing, look, we have some ethical and legal obligations in our lawyer-client relations. We have privilege, and that privilege protects the disclosure of information we receive from clients. That is the very information that the AML-CFT structure may require them to supply elsewhere to an agency within the structure. So they are saying, look, this will put us in jeopardy with our privilege obligations. And that was a narrow issue that the Privy Council had to address. And the Privy Council said, look, AML-CFT and the rule of law are fundamentals in a modern democracy. And whatever privilege you have, it cannot include keeping secrets for criminals and hiding from the law enforcement agencies intelligence and information that they require to combat these serious ills such as money laundering, organized crime, drug trafficking, etc. So the Privy Council ruled that the AML-CFT framework should go ahead. And once we got that green light, we put it into a bill and we took it to the Parliament. And it was passed in August. So they are right when they say that the legal profession and the accounting profession have been excluded, but they also recognized that with the new Compliance Commission bill that is in place, that bill, once implemented, will take care of that deficiency.
Understood.
So that bill has now been assented to, and it will become operationalized. So that issue will be addressed. I think they said something about they said some other issues they identified, but they are, in my respectful view, minimal when compared with the systematic compliance that were found in the entirety of our structure.
Right.
So I believe that Guyana acquitted itself with distinction, And I want to take this opportunity to thank the large number of hard-working public officers, various heads of agencies, and the private sector organs that participated in the process. It was a rigorous endeavor, and a lot of information had to have been supplied to the assessors. The agencies included the Legal Affairs Ministry, the Judiciary, the Ministry of Parliamentary Affairs and Governance, Ministry of Natural Resources, Ministry of Finance, Ministry of Home Affairs. Then you had the law enforcement agencies, KANU, Police Force, SOCO, the Guyana Revenue Authority. Then you had the banking sector. You had the central bank, commercial banks. You had the National Securities Council. You had the Financial Intelligence Unit. You had the entire extractive industry, the Gold Board, the Geology and Mines Commission. You had the Deeds and Commercial Registry, among others. I may miss a couple, but a wide number of agencies were under review. And they had to each subject themselves to rigorous scrutiny. And I believe we did well collectively, and I want to thank all those persons who made this success possible.
So I assume, AG, after having this report, this would be widely covered in the media and would reflect exactly what happened as a result of the preliminary findings that came out of this assessment.
So the assessment process was widely publicized. Our preparation for it was widely publicized. The bills that we passed in relation to it were all publicized, and we stated the reason for the implementation of these bills. So naturally, upon the conclusion of the exercise, I ensured that the public was kept up to date, and I issued in almost verbatim form the report that I received. And it was widely covered in the press, but I am disappointed in an article that I saw in the Stabroek News. What the Stabroek News article did, beginning with the headline, is that it highlighted the shortcomings and did not, in a balanced way, reflect the positives. So if you read the Stabroek News report, you would get a different impression than if you read the report itself. If a report has 10 negatives and 90 positives, but in your coverage of the report, you report on 9 of the 10 negatives and 2 of the 90 positives, then you're conveying the impression that it was a holistically negative report. And unfortunately, that's the opinion I formed when I read the Stabroek News report. I have since drawn it to the attention of the National Coordination Committee, and I have asked them to consider replying to it, because it does not do justice to the review process and the report that emanated from that process. And I feel I'm vindicated in my opinion of the Stabroek News report when I look at the other newspapers covering the same statement that came from the Legal Affairs Ministry in the form of a public statement. So the Stabroek News report front page reads, CFATF assessment finds unified approach. So there's a positive. resources to tackle money laundering lacking in Guyana. Now, this latter one here is a great indictment of the entire system. It's one area, the treaty office, that was identified as lacking in resources. But you read this headline and you get the clear impression that across the board we have a lack of resources to tackle money laundering in Guyana. That's what it says. Resources to tackle money laundering lacking in Guyana. This is a misrepresentation of the report. One agency has been identified. A unit, rather, within an agency. A unit within the Ministry of Home Affairs was identified as lacking in resources. But they used that one critique to castigate the entire system. So this is Stabrook News. I look at the Guyana Times, front page again, and the headline is, Guyana applauded for steps taken to mitigate money laundering risks. Let me read it again. Guyana applauded for steps taken to mitigate money laundering risks. Let's read it. I have the Chronicle here too. Guyana's anti-money laundering efforts strong. CFATF initial findings highlight. Right? Guyana's anti-money laundering efforts strong. CFATF initial findings highlight. So you have, for your reviewers, this is a coverage of the same story by 3 different newspapers, and one says something radically different from the other 2. Hopefully, the National Coordination Committee will issue a statement requesting a more balanced coverage of what Stabrook News reported in today's report.
AG, as we conclude our discussion in relation to CFATF and the work that they've been doing in Guyana, remind the population about why this initiative and this project was extremely important for Guyana's continued development and the fight against terrorism and money laundering.
So, our AML CFT track record has been a very public one, and for a period was a very traumatic one for your listeners. During the 2011-2015 period, we had a minority government with the opposition, AFC and APNU, then separate, enjoying a 1-seat majority in the parliament. What that meant was that government could not have passed anything in the parliament without the support of the joint opposition. Among the things that we were required to pass during that period were a series of legislative amendments to carry out our obligations in the sector. These recommendations, as I would have outlined earlier, they come from FATF through the CFATF to be implemented by the jurisdictions. Every country in the Caribbean had to do the identical thing and did it without any problem. But here in Guyana, the opposition saw this as an opportunity to sabotage the government. They did not take into account or refused to take into account the damage and destruction that they would have done to the country, the financial sector, the private sector, our ability to do cross-border transactions, our ability to do international trade, our ability to do money transfers, our ability to do correspondent banking. All of this were explained by us in government, by the private sector who pleaded with them, by the professional bodies, by CARICOM, who issued several statements, by the Caribbean Financial Action Task Force. Why? Because if you have one delinquent country in a grouping, it brings down the entire grouping. Because countries are sanctioned for trading with a country that is considered to be non-compliant. Because these things are connected. If our banking system is contaminated with the proceeds of crime and dirty money, for want of a better word, and the Barbadian bank does business with our banks here in relation to that account that contains that dirty money, and that money goes to Barbados, it contaminates the Bajan financial system. And that is how it works. It's a chain. So it's all interconnected. So all these organizations and people came down on the then opposition and pleaded with them to pass these bills. That these bills were nothing to do with politics. They had nothing to do with anything other than complying with the international obligations that Guyana as a state owed. That is why I had the responsibility of traveling around the region to explain this thing, including to go to the Caribbean Financial Action Task Force conferences to report on Guyana's inability to pass these laws and to give the reason why. And you know what the people told me, Play? They are not concerned about which political party and why that political party refused to pass the law. Guyana is being judged, and the Guyana Parliament has refused to pass the law. So Guyana will be sanctioned, and sanctioned we were. Up to now, we are still working to dismantle some of the obstacles and hardships that were imposed as part of the regime of sanctions. And we have not been able to complete that process. That's why ordinary Guyanese listening to me are still going through a very difficult time if they wish to conduct straightforward transactions at the bank, commercial banks across this country, including the opening of an account, including the transferal of money from one account to another account. They go through a lot of rigorous processes, and a host of unnecessary information are requested of them. All of this, the opposition must take responsibility for. And we must never forget what these people have done, both in and out of government. That is why I was so emphatic in my presentations in relation to these bills in the Parliament during the month of August. Because I couldn't stand people like Kemraj Ramjatan, who put this country through that, standing now and appearing to play representative of our AML-CFT structure and want to talk down to us on this issue. When he in particular said to the Caribbean Financial Action Task Force and the CARICOM region, when they asked them to support, you know what they said to the people? We are a sovereign parliament, and a sovereign parliament will determine how it will vote. And a sovereign parliament has decided that it will not support these bills, and they voted them all down. Over 3 times. we took bills to Parliament for this purpose, and they were voted down. I spent, and my colleagues in government at the time, spent hours and hours in these studios in explaining this, what we went through during that period. So that is why I decided to update the Guyanese people when there are positive developments in this sector. Because when there were negative developments, I think the Guyanese people stood with us. Because there were widespread condemnation of the APNU AFC conduct. And you look at them now, they have not changed. They have the same approach, destructive, not constructive. But I believe that the recently concluded exercise was a successful one, and it's our hope in government to continue in this trajectory and to work with the Caribbean Financial Action Task Force in crafting a positive mutual evaluation report for Guyana, and of course at the plenary where it will be presented, we will be there to prosecute its successful processing and passing at that meeting.
AG, I want to thank you so much for taking the time to have this discussion with us today.
You're welcome.
You've just heard from the Attorney General, Minister of Legal Affairs, Mohabir Anil Nandlall. Thank you so much for joining us. My name is Shaquan Gill, and I'm saying goodbye for now.